Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Hello and welcome to another podcast in our Arbitration World series, which will be focused upon the challenging subject of expert evidence in international arbitration. Specifically, what techniques and innovations can best be employed so as to ensure that technical and damages-related expert evidence can be efficiently and cost-effectively presented in a way that assists the decision-making process. My name is Ian Meredith, a partner in the international arbitration practice here at K&L Gates, and I'm delighted to be joined today by my colleague Louise Bond, an associate in K&L Gates' London office, and by the leading arbitrator, Professor Doug Jones. Professor Jones is a leading independent international commercial and investor state arbitrator with over 40 years prior experience as an international transactional and disputes project lawyer. He's a member of Toronto Arbitration Chambers, a door tenant at Atkin Chambers here in London, and he has an office in Sydney. He's also an international judge of the Singapore International Commercial Court. Chambers say quite succinctly of him that he's regarded by many as the leading construction arbitrator in the world.
Well, thank you, Ian. It's a great pleasure to join you.
Thank you, Ian. It's good to be joining you both.
Thanks very much. Before we get started, I have some light housekeeping matters to address. I should note that our podcast series is limited in scope as appropriate for a general audience and when working within applicable time constraints. The information in this podcast is not offered as legal advice, which should be obtained only from properly licensed legal professionals on the basis of specific facts of a given case, and all speakers appear in their personal capacity, and any opinions or views offered are those of the relevant speaker alone and do not necessarily reflect the opinions or views of K&L Gates or any other entity of individual. Louise, so that we can better frame the topic we'll be exploring, could I ask you to give a short outline of the various challenges that can arise from the taking of expert evidence, please?
Sure, thank you, Ian. Certainly, a number of concerns have been raised regarding how expert evidence, and in particular that of party-appointed experts, is being used in the practice of international arbitration. I'd say the most common concerns relate to the perceived lack of independence and impartiality of party-appointed experts. In a 2019 survey, 41% of experts surveyed indicated that they had come across other expert witnesses that they perceived to be a hired gun, which is a troubling statistic when you consider that expert witnesses are supposed to agree that their primary duty is to the tribunal and not to the party that appointed them. Another concern relates to the lack of a clear and regulatory framework that governs the practice of party-appointed experts. And third, stakeholders in international arbitration have criticised the reports that are being produced by party-appointed experts in proceedings. Reports have been criticised for being too long and complex, and if they're not properly coordinated, reports can often be described as being like ships passing in the night. That is to say that after many months of work and a lot of money being spent, experts for opposing parties may produce reports simultaneously in proceedings that end up dealing with different issues or approaching the same issues in fundamentally incompatible ways. And this makes it difficult for a tribunal to deal with the reports together effectively. Arbitral institutions have tried to address some of these concerns. Perhaps most recently, the Prague Rules on Efficient Conduct of Proceedings in International Arbitration, which focus on the use of tribunal-appointed experts instead. But I think it's fair to say that parties seem unwilling to sign up to tribunal-appointed experts en masse. Hot tubbing and expert conferencing have also been an area of focus for improvement, but they divide opinion in practice. Many parties opt to follow the IBA Rules of Evidence, and the ICC, the LCIA, and the Chartered Institute of Arbitrators have all released best practice guidelines and notes on the effective use of expert evidence in international arbitration. But these guidelines have been around in international arbitration practice for a few years now, yet the criticisms of party-appointed experts remain. The question is, and what I think we'd like to explore today, is whether and how expert evidence can be employed in proceedings to avoid these criticisms and to ensure that it's adding value to the arbitration process.
Thank you, Louise. It's a real pleasure to have you with us today, Doug. I know that in your own practice of particularly complex international construction arbitration and investment arbitration, expert evidence is often going to be central. You will, I'm sure, have faced many of the issues from time to time, and I know it's an area you've reflected upon and sought to innovate, particularly in your time at the Chartered Institute of Arbitrators. We, of course, have a host of different participants in the arbitral process that each might be said to have a role to play, from the parties, the council representing them, the arbitral institutions that draft the rules, the expert witness community, and others. But if we can start first with what I personally see as perhaps the key aspect, the role of the tribunal can play in setting in place the rules of the game to reduce the risk of party-appointed experts taking fundamentally different approaches. Can I ask you to share some of your own thoughts on what you see as, well, maybe not best practice, but what you see as the best way to avoid ships passing in the night, experts using different documents, different data sets, assumptions, methodology, and essentially getting off on the wrong foot?
Thanks, Ian. I think this is a really important topic for those of us that participate in international arbitration, for the reasons that Louise has identified. And one thing that I would add to what she has enumerated as the challenges is that expert evidence in arbitrations is a very expensive part of the arbitration process. A lot of money is invested by parties in the work of their experts, and in many instances one sees at the end of the day, when one is looking at costs awards, that the amount that has been spent by parties on experts sometimes approaches the amount that they've spent on counsel. So whatever can be done to create a more efficient process for the parties and for the tribunal contributes to the efficiency of international arbitration, which of course is critical to its continued acceptance as the preferred method of resolving international commercial disputes. And when you ask what can the tribunal do, you identify what I think is an absolutely critical issue in developing the efficient use of party-appointed experts and possibly tribunal-appointed experts as well. The key to tribunals contributing successfully to this task is early and ongoing involvement by tribunals in the deployment of experts. And that is sadly something which has been lacking in the past, where tribunals have sat back and allowed the process to develop in the way in which the respective counsel for the parties wish to run the case. And by saying that I think tribunals can intervene, I don't want to be understood as suggesting that the autonomy of counsel to have the right to develop the cases for their clients as they see fit should be adversely impacted, but rather that counsel should be encouraged to work effectively with experts and the tribunal to make it more efficient for their clients and for the tribunal. Now, the first issue, I think, that needs to be grasped by a tribunal, and this is able to be done in most cases very early on in the engagement between the tribunal and the parties, is there any need for expert evidence to assist the tribunal to understand the issues in the case? And in many arbitrations, that is not necessarily necessary. But of course, in complex construction cases and investor-state disputes, and in most major commercial cases where there are issues that need to be explained to tribunals from the point of view of experts in their field, there is a need. But identifying whether there is a need, and if there is, which areas of expertise need to be deployed, can and should be identified very early on, so that there can be reached an understanding between the tribunal, counsel and the parties on what areas of expertise need to be deployed. If there's a dispute between the parties about that, that can be resolved at that stage, very shortly after the first case management conference between the tribunal and counsel. Having identified areas where expertise is going to be deployed, The next thing to do is to identify who are the experts that are going to be used by the parties in a party-appointed context in relation to each area of expertise. Identifying them early enables there to be a limitation proportionate to the dispute and to the need for expertise on the number of experts within each discipline, usually only one from each side, and any arguments that might emerge regarding whether the identified experts are to be challenged as experts in a general sense, and whether there are conflicts of interest associated with the identified experts. So having got through that process of what are the areas of expertise and who are to be the experts deployed, the next challenge is to deal with the issue of ships passing in the night that Louise has identified. Namely, what is it that within each discipline needs to be answered by the experts in that discipline, so that when they commence their work, they will both be answering the same questions. Now, that is such an obvious point that some listening to this podcast may say, well, isn't that something that should happen on every occasion? But of course, when counsel develop the cases for their clients and produce expert evidence in support of each case, they can often be looking at the particular area of expertise from completely different angles. And so getting common questions for the experts early on is critical. That can, in my view, be done pretty early in the dispute process, because when a notice of arbitration is delivered and a reply is given, counsel and the parties are pretty well informed about what the dispute is about. It is often said by counsel, well, we're not quite sure what all the issues are. Well, that's fine and obvious, but at least the fundamental issues are usually clearly defined. So it is useful, in my view, to agree with the parties what are the issues that each area of discipline will be needed to be addressed by the experts in that discipline. And that process can sometimes be agreed between the parties, but in my view, it's always useful to have some tribunal involvement in that process. And in doing that, I often find it useful to have an initial meeting with the counsel and the experts, nowadays virtually, to meet the experts and have them contribute with counsel to what they think themselves should be the questions that they should answer. Now, obviously, each case theory from both sides of an argument need to be reflected in the questions that are developed. And I've found it very useful in this process to have the experts express their views about whether they think the questions being identified are sensible, whether they think there are some other issues that they could contribute to, and so settle what are to be the common questions within each discipline. The next thing I think that is very important is that there be established for the experts from both sides to work from a common database. And that is often necessary to be developed after some disclosure, some exposure by parties of the documents they rely upon, and with the value of some factual witness statements, so that both sets of experts will be relying upon the same material. And in that context, I often find it very useful for the experts themselves to contribute to the debate about disclosure, because in many cases where documents are requested by one party from the other, they're being requested because they're needed, it is said, for the work that the experts have to do. Now, the experts will normally tell counsel what they want. Counsel will normally make a request for documents which doesn't miss anything. and which sometimes can be slightly more extensive than the experts themselves had in mind. And then there'll be a debate from the other party as to whether they should be produced. Now, I find it quite useful in this disclosure debate area to have a contribution from the experts themselves in respect of the documents that are needed for them, and to explain to the experts that the tribunal would appreciate their view on what is proportionately necessary for their work, and that this is not an exercise of absolute finite analysis. The analysis that they need to do to help the parties is something which is of a cost and a proportion that the dispute will allow for. So asking them why they need something, not just what they would really like to have for a perfection process, but what they really need to do a proportionate job, I find often is a useful way of resolving disputes about document production. The next process I think that's critical is that the experts get together out of the sight of the tribunal. That is, they exchange ideas, maybe draft reports, which the tribunal will never see, with a view to developing between themselves, within each discipline, what they think the answers should be to the questions. And where they can agree, they produce, in the first instance, a report identifying what they agree upon, and very succinctly identify what they disagree about. Now, the value of that is that you won't have experts having nailed their colours to a mast on particular views from which they might not be so willing to resile because they've publicly stated a position than they would be prepared to do if there had been a chance for them to talk out of the view of the tribunal about what might be their views.
I suppose it also, to some extent, Doug, also avoids 20 or 30 pages of the experts' report reciting stuff that they do agree on, and which they could have avoided the need in their main reports to focus attention upon if it was common ground.
That's a very good point, Ian. Absolutely. Now, once they've done that, there'll be areas of disagreement which won't necessarily be driven by partiality, but rather by differences of approach, perhaps, which are legitimately available and which ultimately the tribunal has to decide upon, and they can produce their individual reports after that. And when they have differences of view, I think it's always very useful for the tribunal to insist that they put themselves in their colleagues' shoes in the areas of disagreement and say, well, if I actually adopted the alternative view of my colleague, this is what I would think about that, so that you've got an equivalence of view, notwithstanding the differences. Now, this process that I'm describing is one that can't be just set and let run by a tribunal. There needs, in my experience, to be a fairly constant supervision, if you will, by the tribunal of the product from the experts. When they deliver their first set of joint reports, the tribunal should have an opportunity, perhaps, to see whether the work that they have done meets what the tribunal thinks is efficient, and discuss with the experts, with counsel, further work that they might be able to do. And this iterative process is able, I think, to produce a much more effective and efficient delivery of party-appointed expert views. And in that process, I have found that experts appreciate the opportunity to really help the tribunal. There is, with party-appointed experts, the inevitable tension of I'm being paid by someone and I've got to do a job for them. Yet, as Louise has identified, they have agreed when they undertake the role of being an expert to be independent and to provide the tribunal with their genuine views. It's a schizophrenia that remains as a consequence of the appointment process, but I've found that experts do tend to blossom, if you will, in terms of helping tribunals when they have an opportunity to engage directly with the tribunal on a regular basis well before the evidentiary hearing. But I should say that there are three categories of expert in my view. There are the experts, the quantum experts, the valuation experts, the delay, disruption experts who make their careers out of giving expert evidence. Now, they understand the process far better than the second category of expert, which is the expert. That is someone who is perhaps for the first time in an esoteric discipline of metallurgy or computer programming, giving evidence to a tribunal. They're real experts who don't have a lot of experience in actually giving expert evidence. And the way in which tribunals need to work with them is quite different to the way they need to work with the experts who make a career out of being experts. And the third category are the legal experts, who, in my view, are often the most difficult to manage. And I've got a few ideas about how that can perhaps be more effectively done than it is at the moment.
Thank you very much. Thank you very much. I mean, certainly part of what you have highlighted sort of connects to a degree with the sort of expert teaming idea of that Klaus Sachs floated some years ago back down at, I think, ICA in Rio. I remember being there when he presented it. I've not seen it dealt with as much in that idea of the two experts or multiple experts working together as a team. But what you have been highlighting of encouraging the experts to spend more time interacting together, focusing upon what it is they do and don't agree upon, rather than each being in their own bunkers, working on their own reports much more in conjunction with their counsel, has a little bit more similarity to that form of teaming approach.
Yes, I was there in Rio and thought that Klaus Sachs had come up with a great idea. But after I'd asked parties on a few arbitrations whether they would be prepared to adopt his methodology, and they'd been rejected every time, I realised that there was a very heavy commitment by counsel in particular to appointing their own experts, and realised that the teaming approach needed to be developed from a position where you accepted the capacity of counsel and parties to appoint their own experts, but then the tribunal would work with them to see whether a team approach could be developed within that context.
It's very interesting. I mean, just looking at another aspect of the same thing, and we touched upon it earlier, the concept of tribunal-appointed experts, particularly tribunal-appointed experts where the parties come from different legal traditions, or the parties' counsel come from different legal traditions, and maybe feel that not having the ability to have their own experts involved is, if not a lack of due process, then something that reduces confidence in the process. What are your own thoughts on tribunal-appointed experts? When are they really a good way forward? And particularly, when are only tribunal experts, without them being supplemented by the party's own party-appointed experts, a viable solution?
It's very interesting that you talk about differences of culture, because in this context of expert evidence in international arbitration, the history has been fascinating. If one looks at the development, say, of the IBO rules of evidence over time, you see a transition when experts are dealt with from tribunal-appointed experts to party-appointed experts. And as we all know, in many civil law systems domestically, the courts will appoint their own experts, and that tribunal expert appointment process is something very familiar to counsel who come from civil law backgrounds. In the common law, of course, which is a tradition from which you and I come, we've been struggling for many years to try to get value out of party-appointed experts, and the courts have struggled to try and develop processes which reduce the advocacy approach adopted by party-appointed experts. In international arbitration, it's my experience that the lawyers from a civil law background have embraced with enthusiasm the concept of party-appointed experts. And it's very rare now to see a civil law counsel say that they don't want their own expert. The problem is, of course, that those lawyers from the civil law background come without any of the experience that common lawyers have had over many years in their domestic systems about the difficulties with the hired gun advocacy approach of party appointed experts. So as a cultural thing, it's fascinating. However, that said, I think that there can be circumstances where it is possible to avoid just adding another expert to the mix by the tribunal appointing its own expert, which can happen where the tribunal says, well, we want an expert to help us. And then each party has their own expert, and you've just added another third of cost to the process. Just to give you an example where I've found it works well, a joint venture breakup dispute in international arbitration. There is a dispute about the accounts of the joint venture, perhaps. And I've had a couple of cases in that context where it just seemed to me to be a total waste of time to have three accounting firms developing three sets of joint venture accounts from which the arguments of division of the assets will proceed. And I have succeeded in persuading parties to appoint one accounting expert to do the accounts, and then you can proceed from there. And we've avoided the triumvirate approach in that context. The other context is an interesting approach to legal experts. In the Singapore International Commercial Court, of which I'm an international judge, we have a practice at first instance and on appeal to appoint an amicus, an expert in the particular area of legal endeavour which is being argued, where there's a very specialised issue of law from perhaps another country, but more likely international law in the context of a review of international ISDS arbitration, say seated in Singapore, or where there is a particularly novel and developing area of law, such as new forms of currency, for instance, or aspects of intellectual property. And in that context, we have a practice of appointing one, usually, sometimes two, amicus advisors to the court who prepare a detailed report on the particular legal question with the consent of the parties, and someone who is identified by the court usually as a leader internationally in the field, but agreed to by the parties. And the value of that contribution I have found to be very significant indeed, because however counsel try, they probably don't cover the field in areas like that as well as one person who's just given the job of dealing with a particularly difficult area of law. Now, it seems to me that that is a model which could be applied in international arbitration to avoid what one sees very often in the context of arguments about legal system rules and the like of two usually retired judges who seem to disagree on the points of law, and surprise, surprise, their disagreements happen to favour the party who appointed them.
How do you feel about proof of law generally? I mean, I had a number of cases where one party wished to make submissions through counsel, even if that were a counsel that were brought in specifically to address a law that was different from the governing law of the agreement. And the other side wished to call an expert, and you then had cross-examination, the question of whether you had asymmetry of approach. So one series of efforts to prove the point was subject to cross-examination. The other was simply made by way of submission. How do you try to square that circle in your own practice?
It comes from the peculiar English law of evidence notion that foreign law is a question of fact. Now, in international arbitration, no law is a foreign law, in my view. And of course, in international arbitration, the rules of evidence that might apply in an English court do not apply in international arbitration. So it's common lawyers used to this quaint concept of proving foreign law as a fact that has led to their desire in international arbitration to call legal experts. It is, in my view, far more effective for there to be co-counsel from the particular jurisdiction arguing the law and debating that with the tribunal as the case proceeds. But as you say, some people are really keen on having their expert witness produce, a senior lawyer from the particular jurisdiction, and in that context, it is best, I think, to avoid asymmetry. So if the tribunal can't persuade the parties to do it by way of submission, then you do have to have an equality of approach, I think. And it's a matter of finding a process where both parties feel comfortable and not at a disadvantage one from the other. But in that context, it could be, I think, usefully considered for there to be a tribunal-appointed expert on the particular issues of law that wouldn't otherwise be the subject of evidence from two experts from that jurisdiction, senior lawyers.
Just moving on to the sort of final stage of things, well, near final stage, looking at the hearing, how do you feel about direct examination or presentations of experts? Do you like to replace direct examination with relatively short presentations by the experts before we move to cross-examination? Do you like to have no form of cross-examination or direct before hot tubbing and witness conferencing before there's been cross-examination? I just wonder what your thought is in relation, let's put it in the context of one of your complex commercial construction arbitrations where there are highly technical issues and some still remain in dispute. What would be your thought in terms of the balance between presentations, cross-examination afterwards, and having perhaps witness conferencing later in the process after that's gone on, or deciding if it's hot tubbing, we'll do that first and maybe clean up afterwards?
I think it depends on the particular area of expert discipline, at least in theory. From a practical perspective, it depends very much upon the comfort level of counsel and the nature of the remaining differences between the experts. Sometimes, irrespective of counsel's desires, it is useful to have some cross-examination by counsel first, after, of course, an initial presentation by both experts of why they have a different view on the areas where they differ. So I think I always like to see both experts sitting together from the commencement of the expert evidence process within each discipline, both of them making a presentation before any cross-examination of why there are differences between them, and then counsel would normally start some form of cross-examination. Sometimes often counsels from civil law jurisdictions will say, well, we would like to leave the initial questioning to the tribunal. That is less common, but I've seen it a reasonable amount. And in that sense, the tribunal needs to be right on top of the differences. It is a pretty rare case where the tribunal is better prepared than counsel. The tribunal clearly should be prepared, but counsel has lived with the case and understands it a lot better. My approach is to see whether there is a level of comfort with counsel allowing the tribunal during the cross-examination process to choose moments at which it will invite the expert not being cross-examined to express a particular view on an issue when counsel has finished cross-examining on that issue. Don't let the experts interrupt, but at the invitation of the tribunal and the consent of counsel, you can have an issue out and discussed between the experts and the tribunal, sort of issue by issue. And that creates a sort of running hot tub, if you might like to say, when the experts are sitting together in any event. Sometimes when that works well, there's no need for a hot tub at the end. Hot tubbing, I think, was invented in Australia, or at least the phrase hot tub was invented there, and is thought to be valuable to enable there to be a discussion between the experts and the tribunal about their differences. But my own view is that unless you do detailed work between the tribunal and the experts in the lead up through the process of the development of the arbitration, the value of hot tubbing is largely lost.
That's very helpful. What are your thoughts on putting additional questions from the tribunal to experts at the end of the hearing? Do you feel that we have enough post-hearing briefs and counsel putting further forward is sufficient? Do you feel that there's ever a role for experts post-hearing?
Yes, there certainly is in a particular context. To ask the experts to explore new issues after the hearing is an admission that there has been inadequate engagement between the tribunal and the experts in the lead up to the hearing. So I'm not in favour of that, because if the tribunal's done its job with proactive case management of the experts, you are not likely to be looking at new issues that they need to go away and deal with. However, there are often areas in, say, calculation of damages and the quantification of particular areas of delay or disruption where there will be a range of differences of view on the facts and on methodology, which the tribunal will need to resolve in order to get to an answer in the particular area of expertise. What method evaluation should be used? Are there to be assumptions about what occurred that influence what the experts do? Hopefully, the experts will have looked at the position from each other's point of view, as I mentioned earlier, so they won't just be their own views without regard to what their views would be if the other experts' methodology or facts were adopted. But when one is writing an award, you reach a decision point on these matters, and you then need to convert from that decision what the outcome will be by way of calculation or the like. It is sometimes possible for experts to give the tribunal a model into which the tribunal can put its decisions and which will automatically then produce an outcome. But in many cases, the variability of the matters that the tribunal needs to decide makes building a model very expensive. So what I have done in a number of cases, and it's been done by agreement in every case where I've sought it, is to have a tripartite agreement between the parties, the tribunal, and the experts, for the tribunal to have confidential access to the experts during the period of the preparation of the award, so that the experts can do the calculations, there being no model, on the basis of the tribunal's findings that lead to the necessary calculations being made by the experts. No new material, no new expert evidence, just having done what you've done, what do you say jointly? The answer to the calculation is given this assumption the tribunal has asked you to adopt. And you then give the parties, after the award, the material that the tribunal has got from the experts so that there can be corrections or other things applied. And that ensures to a much greater degree of accuracy that the tribunal will get the figures right.
That's excellent. I know, just sort of turning back to what we discussed really at the outset about ways of driving the preparation of the initial experts' reports, that you've done some work with others in the formation of some draft procedural orders, protocols, and other forms of suggestion of ways in which tribunal can help to structure things in that way. I think you indicated you'd be happy for us to attach examples of those to the recording here, so those of our audience that would like to look at examples that have been put together can refer to them, and I think that would be very potentially very helpful for those listening to this podcast.
Yes, I'm certainly happy to do that. There's no one model that should be adopted for every case. There needs to be horses for courses, and the development of the best way to do this is, for me, a continuing learning experience. But I must say that where this proactive approach that I've described has been used, the value for the parties has been huge, because what it means is that the parties will understand at a much earlier stage than before they get the award what the parameters are likely to be within each expert discipline of the likely differences of view. And that helps parties often reach a settlement.
I guess it also, to some extent, helps to minimize cost and delay. If you've got people coming up with, suggestions for different test work partway through the sequence that perhaps could have been agreed earlier, and that additional test work takes months to complete to get results, you're building in additional delay, aren't you, into the whole process, which perhaps could have been avoided if people had considered those matters at an earlier stage. Well, thank you very much for your time, for running through these issues in such detail. I'm hopeful that it will be of considerable advantage to our audience in due course. So thank you very much indeed for your time, Doug.
Thank you, Ian, and thank you, Louise. It's a pleasure.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.